So good morning, everyone. Welcome to this first panel of the day. My name is Nicolas Vermeys. I'm the director of the CRDP, the Centre de Recherche en Droit Public, as well as the associate director of the Cyberjustice Laboratoire. So I join my colleague, Nicolas, in welcoming you to the Cyberjustice Laboratoire this morning. And so to kick off this first panel, which is entitled Guided Discussion on Regulating AI in the Justice Sector, i.e. the regulatory reflex. I have with me four distinguished panelists. Their biographies are in the program, and so for the sake of being brief, I will simply introduce them according to their titles. So behind me is Arnaud Latil, who will go first. Arnaud is a senior lecturer at Sorbonne University. He will be followed by Bertrand Gervais, who is the director of the Registry and Register of Appeals at the Montreal headquarters of the Quebec Court of Appeals. Following Bertrand will be Aimé Salyzyn, who is a professor at the Faculty of Law in the Common Law section of the University of Ottawa. And last but certainly not least, Aimé Toumelin, who is the CEO and co-founder of Hadaly. And of course, again, I invite you to look at their CVs because this just reading their titles does not do them justice. But again, I'm more interested in what they have to say than what their CV has to say. And so without further ado, I'll cede the floor to Arnaud. All presenters will give a 10 to 15 minute presentation, probably 15, let's face it, we're in a university. And afterwards, we'll have a discussion amongst ourselves. And so Arnaud, the floor is yours.
Thank you, thank you. Good morning, everyone. Thank you so much for having me. It's truly an honor and pleasure to be here with you today to address such an important subject that lies at the crossroad of law, policy, and technology. I mean the governance of AI in the European Union. As a researcher in digital law field, as me, and as an expert at the AI office, this is obviously a subject of interest. And thank you to give me the opportunity to share my thoughts on this timely matter. As it be said, first of all, this issue is not only a domestic regulatory challenge for Europe, but also a strategic geopolitical matter. As all of you know, I assume the so-called Brussels effect is closely watched across the world. And EU has not simply produced a set of rules on AI, but also has built an entire governance architecture, combining legal instruments, industrial strategy, and democratic principles. As Professor Karim Benyeklev suggests this morning, the EU stands alongside innovation. Here's how EU tries to struggle. And to fully grasp this governance model, we need to understand that the EU ambitions is to strike a careful balance between innovation and ethical safeguards, between sovereignty and openness, and between effective regulation and flexibility. So the key question then is this: how does the EU navigate these conflicting ambitions? My observation leads me to think that part of the answer lies in its governance framework, which is built on one central principle. There will be no AI in Europe without regulation, and there will be no regulation without stakeholders included in the process. This is the key element I want to expose to you today. This is the main characteristic of the EU AI governance framework. I propose to call this approach the technical deliberative democracy. I borrowed the notion of deliberative democracy from Rawls and Habermas, among others. And I carefully listened this morning, Professor Mireille Hildebrand. This is a theory because this is falsifiable. My theory comes from observation, but it aims to explain the real world. With a bird's eye view, technical deliberative democracy stands as an hybrid model, blending industrial policy and co-regulation. So, on the one hand, I said technical deliberative democracy contains industrial policies in order to promote European technology. but it comes with certain constraints for stakeholders. And on the other hand, you can help stakeholders without listening to them. So this is why I call this approach technical deliberative democracy. It is a model built on the idea of a dialogue between the legislator or regulator and stakeholders. So, first of all, why do stakeholders occupy this position? To understand it, we have to step back at the beginning of the internet in the 90s. As you might remember, at that time, the European legislation, it was the e-commerce directive, basically was a carte blanche addressed to the tech industry with no civil or criminal responsibility. Now time has changed. The EU has chosen a different path. It regulates stakeholders, acknowledging that free market is not enough, but with them, not against them. So let me turn to my second question, how to involve stakeholders in the AI governance architecture. My presentation will focus on this point. To answer this question, we must remember that the EU, the regulation of AI is inspired by the so-called risk-based approach. It aims to encourage innovation while safeguarding against certain risks. To achieve this, it is essential to involve stakeholders for at least two reasons. First, if the risk were managed solely by the regulator, the process will be disconnected from reality. And second reason, AI is changing so fast. The regulation needs to be flexible and to do so connected to the industry and to the civil society. It needs to be deliberative, as Abema said. So to present this theory, I would like to explore with you the three pillars of the governance. The first one is the promotion of European AI developments. The second one is related to the normative deliberation process. And finally, closely linked with the second pillar, the compliance program is the last pillar of this technical deliberative democracy. So the first pillar is the promotion of European AI development. As you know, Europe faces a competition from the US and China, obviously. And at the first glance, it appears to be a traditional industrial policy aiming at industrial sovereignty with classical protectionist tools as trade barrier, tariff, or quota, or again with state aids. But here it is different. It's not only trade barriers and state aids, but the EU also wants it to be, so I said deliberative, in a sense that stakeholders are closely involved in the economic choice. Let's turn to the two mechanisms put in place to do so. The first one is the AI Continent Action Plan. Difficult to understand, yes, but what is it? It is a plan of 200 billion euros investment to create 13 AI factories. In practice, they are supercomputing centers, and as Sam Altman says last week, the future of economy is power computing. So 13 AI factories and 5 data gigafactories. The goal is to produce AI in Europe with European infrastructure and European data. It is not a mere industrial policy with a significant role played by state actors. Stakeholders remain free to develop products and services as they want. We can see the AI Continent Action Plan as a way of filling infrastructure investment gaps in Europe. And the second mechanism is the Apply AI strategy. The Apply AI strategy just released last week, and it fosters a dynamic approach of collaboration among stakeholders. It is very deliberative. The EU acts as a manager trying to bring people together in order to collaborate. The AI Apply strategy is ambitious and comprehensive. Here are 4 takeaways of this recently published strategy. It focuses on 10 strategic sectors like healthcare, robotics, or energy. For example, Commission will launch an AI drug discovery channel to identify potential new drugs. The Apply AI strategy also established the Apply AI Alliance, which is a platform connecting stakeholders to the Commission. As the Commission put it, I quote, "Our objective is to listen to as many voices as possible." It also announced the creation of an AI Skills Academy, which has the ambition to gather all the initiative of the training initiative in Europe. And finally, a part of this strategy is to create an AI observatory. Will be launched to provide tools, KPIs, and to monitor trends about AI. The second pillar is the normative deliberation process. At the core of the EU AI approach is the regulation of 30 June 2024, better known as the AI Act. And this text embodies the European approach of deliberative normative process by at least 4 mechanisms. The first one is the CE marking and standard setting. Maybe you are aware about the CE marking. It is based on an harmonized technical standard, like ISO, for instance. And the crucial point is that the standards are not dictated top-down by the regulator or by the legislator, but are designed by the stakeholders, industry, civil society, and researchers. In other words, stakeholders themselves define what it means to comply with the law. The second mechanism is the code of practice. The code of practice was prepared by independent experts, including from Canada, and published in last July. This voluntary tool allows provider of general purpose AI model to demonstrate compliance with the AI Act by signing the code of practice. It is important to notice that the code of practice is not a legal code, but more a contract, and contract is very deliberative. The third mechanism is the AI Pact. The AI Pact is an initiative aimed at building trust and understanding. It includes information webinars, a services desk to answer legal question, and a compliance checker tool. And finally, this normative deliberation process includes an AI regulatory sandboxes, which permitted stakeholders to test, to experiment with high-risk AI system in real-world conditions under legal supervision. And to finish, the last pillar is the compliance program. Compliance program is closely linked with this technical deliberative democracy. As you know, the AI Act has adopted a risk-based approach, and we can summarize this approach saying the higher the risk, the stricter the obligation. And in practice, compliance means that stakeholders must map and assess risk, must implement mitigation measures, report serious incidents to national bodies, and collaborate with national and EU bodies in post-market surveillance. This is more than just ticking regulatory boxes. It reflects an ongoing dialogue between regulators and innovators. And it also acknowledges a simple truth. The EU cannot predict the future risk of AI technology. EU needs stakeholders to do so. So more than a technical regulation tool, the AI governance framework is a political experiment. It seeks to balance normative authority with democratic adaptability, sovereignty with openness, and regulation with economic ambition. And the success of this framework will depend on at least two things. First, preserving, as it has been said this morning, preserving EU core value, human dignity, democracy, and the rule of law. The technical deliberative democracy is part of the check and balances regarding the rule of law. And the second condition of the success is to gain the trust of the stakeholders. As I said before, the regulation must take place with them, not against them. Thank you for your attention.
Thank you, Arnaud. So Arnaud gave us an idea of a more national, or in this case, international or European legislative approach. And now Bertrand will give us an idea more of how the courts themselves are trying to regulate the use of AI in the justice sector. So Bertrand, the floor is yours.
Thank you, Nicolas. I have been asked today to speak to you about the principle and guideline issued by the Quebec Court of Appeal regarding the use of artificial intelligence by lawyer and party. My brief research has revealed that there are different approaches used to date by the court to address the issue of the use of artificial intelligence. As far as I can see, there are three different approaches. First one, there are courts that have chosen an approach that I will describe as interventionist with regard to the use of artificial intelligence. That is to say, they ask the party to disclose the use they have made of artificial intelligence in the context of drafting their legal proceeding. For example, the federal court has the most comprehensive policy on artificial intelligence use. Party must advise the court by declaration if and how artificial intelligence was used in the court filing or in litigation material used to prepare for court. A declaration is not required where artificial intelligence has been used merely to suggest changes, provide recommendation, or criticize content created by a human who then manually implements those changes. The general rule is that a declaration is required when the artificial intelligence program acts as a co-author in some way. The federal court has posted a video on his website that explains a little about the genesis and the choice of this approach. Justice Sébastien Grandmont gave a very interesting presentation on the subject. Without going into details, I understand that the federal court has not had a great success to date with such an approach, and I base this on the statistics cited by Justice Grandmont in this video. Between the time the directive was issued in December 2023 and the time the video was published in October 2024, out of approximately 20,000 pleadings filed with the court office, there were only two statements made by a party to the effect that they had used artificial intelligence to draft their pleading. Apparently, the decision to ask the party to make such a declaration does not seem to be followed. Justice Grandmont, without explicitly saying so, state in the video that the federal court suspected that artificial intelligence must have been used more in many other procedural acts, even though no declaration to this effect have been made by the lawyer. In this video, Justice Grandmont wanted to reassure the legal community that the requirement to declare the use of artificial intelligence was not a witch hunt, but clearly the lawyers do not have the same opinion. The other approach that has been adopted by several courts is to issue opinion to remind the legal community to exercise caution with the use of artificial intelligence. In these opinions, in this notice, litigants are reminded of the danger associated with use of artificial intelligence, particularly regarding false legal information and false case law sources that can be generated by artificial intelligence. Finally, there is a final approach chosen by certain courts which consists of specially tackling false judicial decisions generated by artificial intelligence. Some courts have chosen to put in place measures to ensure that the case law sources cited are indeed real judicial decisions. This is notably the case of the Ontario Court of Appeal, which has chosen to require that counsel must provide a certification as to the authenticity of the authority cited in their factum. The Quebec Court of Appeal has chosen to adopt the second approach. That is, we have published, and we can see this, and we have published a notice reminding party and lawyer to be vigilant with the use of artificial intelligence. This is also the approach chosen by the other Quebec court, and I see that the Chief Justice of the Superior Court is here today, so so Madame Justice Paquette. So this is also the approach chosen by the Superior Court of Quebec, the Court of Quebec, and Municipal Court. So on August 8, 2024, the Court of Appeal issued the one that you see, the notice. I will not read it, but you understand that it's said to everybody, just be caution to the use of artificial intelligence. And the warning in our notice is essentially the same as we can find in the notice issued by the other Quebec court on the same subject. However, the Court of Appeal of Quebec had decided to go a step further to counter false judicial decisions generated by artificial intelligence and without prejudice. I believe that we are the only court to have implemented such a measure, but I'm not 100% sure. It is the third paragraph of the directive that you see there. And the Quebec Court of Appeal adopted some time ago a directive about the rule, and you have the rule respecting the preparation of PDF file with or transmitted to the court. At one time, we received several PDF in image format, and the judges pointed out to us that such electronic documents were a little used to them since they were not able to use them to their full potential, for example, by doing keyword searches. We therefore issue this directive with a series of requirements that the party must respect each time that they file a PDF version of a pleading to the Court of Appeal. One of these requirements concerns the Book of Authority, and I will read to you the extract of the notice that you see. If the list of authority contains reference to judgment, it must include an hyperlink to a recognized website that is accessible free of charge. And you have an example of what we can see right now when we receive some Book of Authority. The purpose of this requirement is to facilitate the work of judges by allowing them to quickly access cases law on a website. But we had another objective that is not mentioned textually, but which we had in mind. The objective was to counter the filing of false case law decisions generated by artificial intelligence. Indeed, by asking the party to provide us with an hyperlink to a recognized case law database for each of the decisions cited in the Book of Authority, we went to ensure that the judgment invoked by a party actually exists. Today, the vast majority of judgment are published in electronic database accessible free of charge. I am taking here in particular of the Canley and Sekij website. Why the Court of Appeal chose this approach? The question what we had in mind when it came the time to decide which approach to take was this. What use is to us, the Court of Appeal, to know that a party has used artificial intelligence? We came to the conclusion that what happened inside the law firm is not our business. Whether a pleading was drafted by a junior lawyer, an articling student, or paralegal is a decision for the lawyer responsible of the case. Similarly, whether a lawyer used artificial intelligence or to draft all or part of a pleading or to assist them in a legal research is their choice. I remind you that at the end of any procedural act, the Court of Appeal, like other Quebec courts, require that the act be signed by the lawyer or the unrepresented party. This signature is not only a symbolic gesture, it engages the responsibility of the signatory and may lead to legal or administrative consequences. If a lawyer is negligent enough not to verify accuracy of the information or sources generated by artificial intelligence, he or she will have to bear the consequences on the subject. The Code of Ethics of Lawyers of Quebec already contains everything necessary for a complaint to be made against the lawyer in question. And indeed, you see the relevant section, but I will not read it, but already is there. It's not new section, it's a long time ago that there is there. So note that there is nothing new under the sun. We have already had in the past, well before the advent of artificial intelligence, false cases law that was filed. I assure you that is very rare, but it's already happened. I remember a judge, Justice Baudouin, that was a professor here at the time and was judges at the Court of Appeal also. In the late 90s, he realized that a lawyer had produced a false case law. He filed a complaint with the bar and disciplinary sanction were taken against the lawyer. All this happened well before the era of artificial intelligence. The only difference is that at the time, the lawyer had to draft the false case himself, which took much more time than it doesn't now. The other reason that motivates our choice is that we also have to be of your times. When we become aware of certain excess that have occurred with the use of artificial intelligence, the first temptation we might have had is to simply prohibit its use. This is certainly not the right solution. I remember having a discussion with one of my friends who is a professor at the management faculty in Sherbrooke University. We were talking about the use of artificial intelligence by students, and at the time, my first instinct was to tell him that I hope that this faculty will formally prohibit students from using it. Imagine my surprise when my friend told me, "No, Bertrand, on the contrary, we are going to encourage our students to use artificial intelligence, but what we are going to do is teach them how to use it properly." I believe that that is the same approach we must have with artificial intelligence in the legal world. We must not be fooled. Firms already use it extensively, but what we must ensure is that they use it properly to avoid abuse. In reality, the real danger, in my opinion, is not the use of artificial intelligence by the lawyers. The lawyers, in principle, have the legal knowledge to carry out the necessary check and detect falsehood generated by artificial intelligence. Moreover, from what I have read on this subject, it seems that lawyers who have been caught using artificial intelligence have rarely done so in bad faith, but rather due to a lack of time, overconfidence in their staff. For my part, my main fear about the use of artificial intelligence is more related to the people who represent themselves before the court. This is a major problem. There are more and more of them at the Quebec Court of Appeal, and I presume also in other Quebec courts. With the advent of artificial intelligence, it's a golden opportunity for them to be able to produce procedural documents of better quality. However, these people do not have the legal knowledge to detect falsehood generated by artificial intelligence. That is the real danger. Coincidence or not, and I will conclude on this. I came across a newspaper article published in the daily newspaper Le Soleil on October 17th, so last week, or the very recent, that related a case that confirmed my fears. In this case, the applicant was represented by a lawyer at the beginning of the legal proceeding. However, for some unknown reason, probably financial difficulty, he chosen to represent himself before the Superior Court of Quebec. And I finish on this. I will read some part of this article and I make a translation. Representing himself, he turned to artificial intelligence to prepare his argument. This was not a good idea. He was ordered to pay $5,000. Why? For having committed a serious breach of the proceeding by inappropriately relying on artificial intelligence in preparing his proceeding. The judge also noted that this is a social trend that our justice system cannot avoid. Supported by a lawyer until very recently, the applicant represented himself before the Superior Court. However, the opposing party's lawyer detected that the applicant defense contained several citations to authority and case law that simply do not exist. The applicant acknowledged relying on the full potential of artificial intelligence and apologized for submitting inaccurate documents. And that is the more interesting part of the story. However, according to him, he will not have been able to adequately defend himself without resorting to artificial intelligence. He said to the judge, I didn't have the choice. The judge decided that he had to take action against the result of this artificial assistance. The judge writes in his judgment, while access to justice requires a certain flexibility on the part of the courts towards citizens who must represent themselves without the assistance of a lawyer, this can never translate into tolerance of falsehood. Access to justice can never accommodate fabrication of pretense. So that's it.
Amy, the floor is yours.
Perfect, thank you. Yeah, that's a wonderful transition. I'm going to now talk about regulating AI in the justice sector, and I've been asked to talk in particular about regulating legal professionals. In terms of the 15 minutes that I have with you today, I'm just going to begin by setting really briefly some foundation, talking about kind of the explosion in generative AI legal tools that we've seen both in Canada, but certainly internationally. Then I'm going to talk about regulatory responses from legal service regulators in particular. And then finally, talk about what I think are kind of three big issues or kind of three pressure points going forward. You could probably name many more, but in 15 minutes, three will, I think, suffice. So to begin, what is happening with generative AI in the legal services sector? Well, certainly, and we could talk about how you define AI, but we can have, I think, agreement that AI tools have been used for a while in the legal services sector. The paradigmatic example is e-discovery, so something that I think can fairly be called AI has been used in e-discovery for well over a decade. But certainly with the introduction of ChatGPT, the public release, the introduction of that technology did kind of blow a lot of people's minds with this demonstration of the ability to generate human-sounding text with a really easy-to-use interface. And for so long in AI, in legal AI, language was a barrier. And it took a lot of time to structure data sets, and producing legal language was very difficult. And so this ability of this kind of word machine was not something we had really seen before in legal AI. And kind of immediately people got excited because they looked at the work that lawyers do, right? So much involves engaging with language, reading case law, drafting pleadings, drafting contracts, drafting legislation, communicating with clients. And so this word machine was presented to the world, and very quickly people, a number of industries got excited, but the legal industry was definitely one of those. You may remember some of the really breathless headlines that came out really soon, and some which struck fear into lawyers' hearts about how well ChatGPT in particular was performing on certain legal tasks. To connect to the presentation we just had, kind of shortly thereafter, though some of this excitement got dampened, we started seeing some real-life examples of things going wrong when legal professionals use this technology improperly, talking about this issue of AI hallucinations entering courts. First happened about maybe 7 months after ChatGPT was released. First kind of high-profile instance was an American lawyer who had used the tool. He had a motion involving a lawsuit against an airline, was super excited that the tool yielded some cases that would show definitely he'd win his case, some cases kind of directly on point, how lucky. Filed those with the courts, no one could find them, and it was quickly determined those were hallucinations. Made the front page of the New York Times, not for good reasons, and then was also sanctioned $5,000. There was kind of in kind of the kind of legal ethics, legal regulation space, there was kind of this sense that, well, this hallucination problem is going to burn out. Don't necessarily be focused on this, because after lawyers see this lawyer on the front page of the New York Times, surely lawyers will try and avoid the same fate and not use this technology in this careless way. Opposites happen. We've actually seen a huge acceleration of these AI hallucination cases. You may not be able to read the screen, but there's a French researcher keeping a database, and it's collected 432 instances. Some of these involve self-reps, but a large number involve lawyers. This is a really, by far an undercounting of what's actually happening. The actual cases exceed. And if you kind of look at the trends of cases, we're seeing a huge uptick as more lawyers become introduced to this technology and are using it. So it hasn't burnt out, it's actually accelerating. Talking about the landscape of legal AI, this concern about reliability is one reason, among others, that the commercial legal tech industry has become involved. Other reasons involve cybersecurity and interface adaptations. But there's been a massive amount of developments in the legal AI space. You're definitely not going to be able to read those logos, and I'm not going to read them all to you. But people are keeping inventories of what's available on the market. This is just legal tech tools that use generative AI that are designed specifically for lawyers. People are keeping these inventories. This one, I think, captures over 630 tools. We're talking about millions, if not billions of dollars being invested into this industry. And this is just, again, the legal tech industry using generative AI. So a huge industry that's pushing these tools out to lawyers. What can we talk about kind of what's happening with these specialized tools? That's a longer conversation to have. I just note that there are continuing questions about performance, depending on what you're trying to do. The legal research space is one example. And I think this, we can discuss why this happens, the probabilistic nature of the technology. And so right now, we're at a place where the unpredictability and unreliability is definitely a feature, not a bug. Again, that doesn't mean you can't use the technology responsibly for certain things, but it does impose a real limitation. So there's performance questions. There's also questions about actual adoption. And here we heard about PR in our keynote. It's really hard to kind of cut through the hype and what's actually happening. There's a lot of legal workplaces that are adopting these tools so they can tell clients they are, not necessarily using the tools. But the tools are being used certainly by some legal workplaces. Though if you look at the actual stats, a lot of legal workplaces are using some of the general tools, whether it's ChatGPT or Microsoft Copilot, not necessarily these specialized tools. So wait and see how that shakes out. One reason why there's probably a lot of continued use of general purpose tools is cost. That big array of logos I showed you, this development's mostly targeting large, wealthy law firms. Definitely not exclusively, but there's a large amount of development in that space. These tools can be expensive, sometimes $1,000 a head or more in cost. And so cheaper tools can be attractive. There's also a lot of shadow AI use where even tools haven't been onboarded by the law firms explicitly, but lawyers are still using them. One concern that arises from this reality is a concern about kind of a further entrenching of a two-tiered legal system where you have some general purpose tools that may not be fit for use in the legal space being used by certainly self-represented litigants and then maybe lawyers from less wealthy legal workplaces. And then you have the more high refined tools being used by large law firms. Also a concern about the state and the government being able to use some more bespoke tools, and also the government being able to use leverage data that they have. And so concerns about what this is meaning for the legal services space. That was extremely high level and missed a lot, but tried to capture some of the highlights about what's happening with legal AI right now in Canada, but also beyond. I'm going to talk a bit now about how legal service regulators have responded, noting that I'll be focusing on kind of law societies, bar agencies. The courts are certainly another legal service regulators we just heard, and there's other sources of regulation, but just focusing on kind of the law society type space. First, certainly to match kind of that explosion of legal AI tools, we've had an eruption of guidance. Over the past 3 years or so, maybe more so 2 years, we've seen dozens upon dozens upon dozens of different pieces of guidance be issued to legal professionals across the globe about using generative AI. And I watch the regulatory space for the legal professionals closely. This is pretty unprecedented in terms of this much activity in such a short period of time around one particular issue. We don't really see this kind of outpouring of guidance typically. Just to give you an example, what's happened in Canada, we're regulated, our lawyers are regulated provincially and territorially. Almost every jurisdiction has issued its own guidance on this topic in the last few years. And that's just national guidance. What are some characteristics of this guidance? I've talked about dozens and dozens of different documents. They're, of course, all different, so they all have their differences in format and focus. I would say there are some generalities for the most part. And here I'll be focusing mostly on English language documents in common law countries. But what are some of the generalities we see there? The guidance does tend to be high level, talking about risks and benefits. It's not really talking about specific tools or really detailed use cases. That makes sense if you think about this being a general purpose technology and how fast things are moving, but that's a characteristic. We don't see in general new duties or new obligations being put on lawyers. Just as we saw in the previous presentation, there's existing duties that can be elaborated in this context, and that's generally the direction that regulators have gone. They talk about, we have a duty of competence. What does it mean in this context? A duty of confidentiality. What does it mean when you use an AI tool? The tone tends to be generally encouraging. I know working with some legal service regulators, they felt a lot of pressure not to be seen as anti-innovative. They felt a lot of pressure to make sure they weren't seen as, anti-future and anti-AI. And so the tone is generally encouraging, this idea that these tools can be used. At the same time, certainly there's a cautionary note that runs through all this idea not to fully trust or delegate to the technology, this idea that, it's your signature on that document, and so responsibility stops with you. This is consistently emphasized. Lots of calls for human in the loop, and I think we see some of that in the court guidance as well. This idea that human verification, supervision, control, review, this comes up verbatim in the guidance is something that's consistently emphasized, and I'm going to come back to that in my third section. The second regulatory trend I talk about, and here focusing on North America, is there has been a shift away from cracking down on digital tools that seek to provide legal services directly to the public. So here moving away from talking about tools used by lawyers, but essentially apps or other services that are meant to be used by the public and kind of take away the need for lawyers. We heard that term regulatory sandbox. This is happening in the legal services space as well. Previously, North American regulators were quite aggressive in prosecuting anybody who is providing legal services directly to the public through digital tools. Now we're seeing regulatory sandboxes pop up where these providers can enter them in a controlled space and provide services directly to the public with an assurance they're not going to be prosecuted. The benefit on the regulatory side is they can collect some data before they make any rule changes. They can also sometimes put controls in place. Utah was the first to have this. A number of Canadian jurisdictions now have these that are ongoing. On to the last section here. What are some of those issues going forward, given what I just said. As I just talked about, a common thread throughout the guidance is to kind of emphasize this need for a human in the loop. On one level, this is great. It does make sense for a number of reasons to say that lawyers need to be engaged when they're using these tools. They shouldn't be deferring completely. They should be supervising, verifying, controlling, and reviewing. My concern here, and some work I'm going to be starting on doing it in more detail, is the fact that the guidance often just begins and ends here. It's kind of like these terms, verification and supervision, are almost used as an incantation to kind of eliminate any risk. Just check it over and you'll be fine. This idea of kind of adding a human and stirring is offered as almost a full defense to the risks without giving lawyers the proper nuance and guidance about what that actually means. And I think for a variety of reasons, it sets up lawyers to fail. It kind of makes them kind of liability sponges, to use a term, where it's saying, use this technology, we're encouraging it, check it, and if something goes wrong, you're going to be in big trouble. And so we have a lot of great frameworks and theoretical and empirical work on human-machine interaction from other fields that we need to start kind of importing into this context, thinking about issues of automation bias, verification drift, thinking about how this technology can be deceptive. All this needs to kind of be built into a more sophisticated account of what it means to engage with these tools. And like I said, in good news, I think we have a lot in other disciplines to draw on that certainly in the regulatory and policy space we haven't yet. Second, I think there's a whole category of concerns related to ethical alignment. I think this is a concern kind of throughout legal systems. As we start to import more AI tools into our processes, I think we really need to start being much more concerned about what priorities are getting encoded into these tools, who's encoding those priorities. There's a lot packed into these tools that are now absorbing so much of the substantive work. There's system prompts, internal instructions, there's data set choices, there's choices about what to prioritize. And all that's getting embedded by private developers. Even if a court, for example, is trying to build its own technology instead of off the shelf, they're still using a foundation model and they're still using kind of the building pieces from private developers. And so, I think some of these effects may indeed be subtle. I don't think there's kind of a grand conspiracy to influence lawyers or the justice system. But I think their accumulation can be significant, and it's not, I think, enough on our radar. So thinking about questions of the independence of the legal profession and judicial independence need to be on the agenda, and I think they are increasingly on the agenda of some people thinking in this space, but it's going to be important. And there's a lot of interest from the industry who spent millions of dollars on these tools to push it into our legal workplaces and courts. I think we need to be a lot more skeptical. And not because people have malintentions necessarily, but because we have different values, potentially different priorities. Finally, this has a future of UPL regulation. UPL refers to the unauthorized practice of law. So again, thinking about those tools that provide services directly to the public. Those regulatory sandboxes I talked about are generally meant to be limited term. They're meant to be a space in which new innovators can experiment and regulators can collect data. What are we going to do with these tools in the long term? I think kind of prior to the pre-ChatGPT world, there was interest in re-regulation. Let's create new regulation for these tools that can impact people's lives in such significant ways. But what does it mean in a world where the public is using ChatGPT to get legal advice? This is already happening, and there's certainly no movement to try and regulate the provision of legal advice by these tools. No even, I think, embrace of the idea this could even be possible. And so I think we're going to be in an interesting space thinking about those direct-to-public tools. They can cause serious harm, and we've seen that, just one example of self-reps using these tools and then filing legal pleadings. We've seen this in the medical world as well. That's my time, if not more. So thanks for your attention, and happy to answer any questions or talk to you afterwards about these ideas.
Thank you, Amy. And again, last but not least, we have Aimé. Aimé showed that slide with the hundreds of logos of AI apps that were used by lawyers or that were built for lawyers. Well, Aimé and his team developed one of those apps. I'm going to say one of the good ones because he's with us, obviously. And so, without further ado, the floor is yours.
Good morning, everyone. Can you hear me? Yeah, perfect. Well, nice to meet you. My name is Aimé. I'm one of the co-founders of Hadaly. Oh, let me just find the first slide. Okay, you will only have the second slide. I'm one of the co-founders of Hadaly, which is a platform that supports M&A professionals for corporate transactions. So basically what we do is we gather a huge amount of data toward corporate transaction, and we study this data and try to give insight during a corporate transaction. Today I'm going to try to give you a perspective on the field, of the reality of how we are using AI as a small business, and how we see in those corporate transactions how AI is used for those small businesses. I'm going to try to walk you through a concrete use cases of a transaction of a 5 million transaction, so a small transaction, and then share with you this experiment that we've done with different law firms in Montreal, and share with you the limitation on what we thought about it. So, as I said, we started Hadaly, so it's a small company that helped during the process of transaction, with the idea of we have those tools that are able to generate and analyze huge amount of text. What if we could apply this to the corporate transaction world? So what if, if I walk you through a transaction, you will have a lot of people, so lawyers, accountants, you will have brokers, sellers, buyers, and all those people are going to try to facilitate this transaction. So what if we could help all those people to minimize the time, to help them to minimize the time of the transaction, and to help them to spend less time for this transaction. So that's what we do this year, and we've helped more than 200 transactions for 450 million in Canada. Of course, there is a lot of limitation and a lot of challenge that we've seen in the field, and especially when we treat and analyze those. So when you have a transaction, and I'm going to go through this use case of 5 million transaction working with 2 law firms here in Montreal, so Delegatus and Propulsio 360. Here it is. I don't know if you are familiar with corporate transaction at all, or is this something that you know a little bit just by raising your hand? No, not at all. Okay. Okay. So I'm going to walk you through the whole process. So what's happening basically right now in Canada is we have a population that is getting older and older, and we need to buy and keep continuing those businesses, so small businesses. So when we saw this opportunity, we were like, let's find a way of facilitating this transaction. A transaction usually works like you have a small businesses, so let's say a small commerce that needs to be sold. So then the seller will try to organize all the data of a company, so financial data, legal data, and put everything in a repository that we call a data room. Then they will try to talk with a broker on the sell side and a broker on the buy side to find a buyer and to try to understand the legal context of the company, but also the financial context of the company to sell this company. So you will have a buyer, a seller, accountant, lawyer. They will try to work together to transmit this company. So here's the step. Of course, you need to evaluate the company, so to put a value on this company, and it's a very interesting question because the value the value can vary depending on the legal context, on the organization of the company, but also on the financial performance of the company. So once you have evaluated this company, then you have to prepare all the documentation. And this is where lawyers use AI to produce the document. And from what we see on the field, a lot of lawyers are currently using AI tools to prepare the documentation, with some limitation as well. Once you evaluate buyer, the company, then you walk through what we call due diligence. So due diligence, basically, it's the you're trying to explain and go through the whole data that you have in the company. So it can be up to thousands of documents with hundreds of pages. And historically, this is done, that's what we call a data room. This is done in a room where you have the lawyer and you try to read the document and try to flag some risk or potential issue that you will find in this document. So that's where the experiment goes. What we've tried to do with AI and what we've tried to do with also mathematical model is to support the lawyer through the reading of those documents to flag some risk and to see if we were able to facilitate this process. So some image about present world. So concretely, that's what we've done. We've done a repository, secret repository, where both parties will upload the document. Then we'll try to read those documents in batch. So you need to extract the information, read the risk, understand in which legal basis it stands, and then put some score out of it. So you have one part which is more about what you were saying. You can't evaluate the performance of that, which is the part of the LLM, and you have the other part which is more about let's try to put some KPI and measure the impact of those companies. So that's about the score. Once we have this, what we've tried to do is to evaluate the real value of the company through a report that is generated and reviewed by a human. So there is a lot of documents in this process. So what we are doing is that we are facilitating the writing of those documents for lawyer. So lawyer will use those documents to generate this tool to generate those documents. The experience we made with those two law firms was let's put all those documents, so status of the company, incorporation, legal document like contracts of fournisseur, contracts of clients, financial statements. Let's put all those documents and try to explain what stands in that. So we put this platform in the hand of those law firms, and they've tried to process corporate transaction with that. What was interesting is that in parallel, we had one law firm that was doing the work manually and one law firm that was using the tool. What we see that the tool was able to find a lot of risk, so approximately 400 risk, and that the law firm manually was able to find the same risk, but the AI was finding more risks than the law firm. The limitation of that is that the AI found some risks that were not really risk. So all the risks were identified as the same, but we had some hallucination, we had some multiple risks that were not really risk, and the real risks were hidden within this kind of slope of risk that was hard to identify. So that was the finding of this experiment. Of course, this was done after 3 years of research and 3 years of working and developing some tools. So it's encouraging, but there is a lot of work that needs still to be done to be able to work on the field. Now, when it comes to the technology of agents, so we saw first you have like prediction model, and then you have LLM that are able to understand text. When it comes to using these LLMs in what we call a chain of thought, so making them talk together, to try to identify and improve the accuracy of the decision we output. That's also the experiment that we've run. So out of those 400 risks that we were able to identify in a company, what we've done is that we've put all those risks in different agents, and we've tried to identify the priority of the risk and the impact of those risks. The findings was that in approximately 70% of the case, we were able to rate good the risk in terms of priority and impact, but there were still some limitation out of that. So to finish, what we've seen with this experiment and on the field, we have some good practices that I want to share with you, and that we encourage small businesses in Canada to do as well. During this experiment of trying to automate the due diligence process of a corporate transaction, what we've seen talking with lawyers is that transparency was super important. So when you output a decision or a risk that you have identified in a corporate transaction, you need to explain why. So it comes to the link that Bertrand was presenting. So you have to identify why you found this risk and what is the potential impact. Of course, it's very private data, so that's one of the challenges that we had. When you have all of the salary of the employee, when you have all of the private data about the employee, the private data about the company performance, you need to be in an environment that is secured, and you need to be in an environment that is in Canada or in Quebec. So that's one of the limitations with the AI Act that we see, is that all of the data needs to be somewhere where the client is. Of course, everything needs to be encrypted. Some traceability needs to be done, so meaning that if you found some risk, you need to identify where did you find the risk in the document, and why it's important to identify this risk. What we realized is that so when we had this tool in hand, what we realized is that one of the choice we had was just to put this tool directly in the hand of buyer and seller, so direct companies, or in the hand of lawyers. And we took the choice to put these tools directly in the hands of lawyer because of professional guidance. And what we have understood is that the small businesses were not ready to have these tools and, as you say, to represent themselves in some court or such this. So that's why we integrated human in the loop. That's very important. And what we see finally is that when you put a model in production that's able to give some insight about risk detection in any process, you need to continuously monitor what are the outputs and what is the difference with the reality. So in our case, for example, when you evaluate a business, so you give a value to this business, you need to have a loop that gives you the value of this company maybe several months later. So that's pretty much about this experiment. We are trying to push this experiment also in Europe right now. So after helping more than 200 businesses in Canada, now our objective is to bring these tools and this platform to Europe to help small businesses to be more transferred.